The next case to come before us this morning is State of Ohio versus Jeremie Banfield. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, if you let me know when we get started, I'm keeping track of time and can let you know when you're getting close to your or into your rebuttal time. Please do not use the names of any victims or minors, as we are streaming this live and also posting on YouTube the recording for later review. We've read the briefs. We are ready to proceed when you are. One last thing, if you are not arguing, if you could please mute your microphone so that we don't have a problem with background noise. And counsel for the appellant, we're ready when you are.
Okay. Thank you, Your Honor. May it please the court, my name is Stephen Hanadal. I represent the appellant, Jeremie Banfield, who would like to reserve 5 minutes for rebuttal. In the brief, I alleged 4 assignments of error. The first 2 kind of go together, sufficiency and manifest weight. The sufficiency argument centers upon the insufficient proof as to whether Mr. Banfield intended to commit a criminal offense when he was trespassing on the property. Burglary is just not a mere trespass. It's trespass plus the intent to commit a criminal offense. And while the state is allowed to make inferences, and the court can make inferences, there still has to be some substantive evidence that Mr. Banfield, in fact, did indeed commit a crime, that it went beyond just a mere trespass. And the state did not present any evidence of, they did not present any evidence that he had any criminal tools or any weapons. So there was no indication that he'd ever, met the victim in this case. And by not having any weapons, there's no indication that he intended to commit physical harm. And he didn't carry a crowbar or a bag to which he could take items, or any other criminal tools that would normally be associated with ransacking a house. So, all the only evidence the state presented was that Mr. Banfield was at the back door in the middle of the day and made an attempt to open the back door. And yes, while that's clearly a trespass, no question about it, it is. But to get beyond that, there has, in order to show that intent to commit a crime, the state needed to present just something, to show that he in fact intended to do more than just trespass on the property. And otherwise, any so-called inferences in this case really amounts to an assumption. And then in the manifest weight argument is pretty much hinges on the same thing, except just arguing that the trial court judge lost his way. This was a bench trial, by the way, did not go to a jury. But and the third assignment of error is I think is perhaps the most critical in this case, because in the trial court judge openly deliberated. He deliberated in open court. I mean, I think he also deliberated on his own, but he very openly shared his thoughts of his deliberations in open court. And in that deliberations, he did comment about Mr. Banfield's silence. That Mr. Banfield did not talk to the police. He refused to answer the door when the police came to his girlfriend's house where he was at. And I think the trial court judge said that he had a difficult time believing there was an innocent explanation for Banfield being at the back door because he did not provide an explanation to the police. Well, Mr. Banfield was not required to provide an explanation to the police. I mean, he has an absolute unfettered right under the Constitution to not speak to the police. And so, because he was under no requirement to offer an explanation, the fact that he did not provide one cannot be used against him. And I think it's pretty clear the trial court judge factored that against him in his deliberations and finding him guilty. And there's well-established constitutional precedent in the U.S. Supreme Court on that. And in Griffin versus California from 1965, excuse me, a prosecutor cannot even comment on a defendant's silence in trial. And that's been well established for over 50 years, 55 years. Wainwright versus Greenfield in U.S. Supreme Court in 1984, that a defendant's exercise of his constitutional rights cannot be evidentiarily used against him. And that's what took place here. So for that reason by itself, this matter needs to be remanded. And when it comes to the sentencing, Mr. Banfield received a 30-month sentence out of possible 36. And the trial court judge made a comment that he had reviewed the state's discovery file, and which now that's not in the record. I mean, there's no such file in the record. So it would be apparent that the judge reviewed extrajudicial information, and which he's not allowed to do in a sentencing context, and or at all, I think, in the entire proceedings. But there.
Counsel, let me interrupt you.
Yeah.
Counsel, let me interrupt you just for a second.
Sure.
I'm trying to remember. His counsel, your client's counsel, Mr. Banfield's counsel, didn't say a PSI was necessary. Did he request a PSI? I don't think so.
I don't think so. A PSI was not done.
Yeah, but I'm trying to remember who wanted a PSI or who didn't want a PSI. I know the court said, I'm not going to do a PSI.
Right.
So was there any evidence presented other than what the judge said at the sentencing hearing in regard to his prior record? Did the prosecution talk about his prior record?
There was some discussion about his prior record. I do believe the prosecution did talk about it, to the best of my recollection, because I'm trying to remember exactly as far as the exact details of it, but I do specifically remember his prior record was discussed. He did, and that definitely factored into the sentence being toward the higher end of the spectrum, because, like I said, he got 30 months out of a possible 36, and yeah, and there is Ohio Supreme Court precedent from 2016 in disqualification of Satula, where if a trial court considers extrajudicial information in a sentencing matter, that does constitute bias against the defendant. And I've been before this particular trial court judge numerous times, and I know that he does not have a mean bone in his body, and so I know that I know he does not wake up in the morning seeking to violate constitutional rights or anything like that, but it's just but everybody's human, and everybody makes mistakes, and I think that's just simply what happened here. As he attempted to engage to openly engage his thoughts in an open court, and talk about his reasons why he was finding Mr. Banfield guilty, and there's reasons why he was giving him 30 months. I think he just unwittingly just tripped over himself and mentioning that, saying, "Oh, I saw the state's discovery file," which again, that raises the question, well, like, what is he talking about? Because there's no such file in the record, and also because the question becomes like, yeah, did that include the Mr. Banfield's leads sheet, which would not be in the record, and there was discussion about Mr. Banfield's criminal history, and then going to the third assignment of error about Mr. Banfield's silence. I mean, how that was used as a factor against him in the trial court finding him guilty. So for those reasons, I mean, Mr. Banfield's conviction needs to be reversed and remanded for further proceedings. And if there's no further questions, I'll reserve the balance of my time.
Seeing none, thank you, counsel. You'll have 5 minutes for rebuttal. Counsel for the
Thank
state.
you.
Yes, your honors. Lindsay Poparki of the Lorain County Prosecutor's Office on behalf of the state of Ohio. In this matter, Jeremie Banfield argues that the state failed to provide sufficient evidence that he intended to commit a crime once inside the victim's residence. However, the state submits that the evidence submitted at trial was sufficient to prove that Banfield purposely engaged in conduct that, if successful, would have resulted in a burglary, as he took a substantial step towards the ultimate commission of his crime. This is a conviction for attempted burglary. Banfield's sufficiency argument specifically focuses on an element of his intent to commit an offense for purposes of the underlying crime of burglary. It has been noted that the element of intent, because the intent of an accused dwells in his own mind, it can never be proven by the direct testimony of a third party, and it need not be. Rather, it must be gathered from the facts and circumstances surrounding the case. Case law, including State v. Flowers, has held that a reasonable inference exists that if a suspect uses force to enter a structure, he is there with the intent to commit a theft offense. This inference has been recognized in the context of attempted burglary matters. As a case cited in my brief, State v. Daly, which is a factually similar case, the 8th District upheld an attempted burglary conviction. In that case, the victim testified that she saw a man at her kitchen window standing on a porch swing located below the window, trying unsuccessfully to push open the screen on the window. After not calling 911, the victim saw the man put his hands around his face and peer through the window. He then disappeared. The victim surmised that the man either saw her in the kitchen or realized that the window was locked. The Daly court cited Flowers with approval and held that the state's evidence, if believed, was sufficient to give rise to an inference that the defendant attempted to enter the victim's home, intending to commit a theft offense, but either left when he saw her in the kitchen or was unable to unlock the window. The same analysis applies here. Yes.
These were sliding glass doors, right?
In this case?
Yes. Mm-hmm.
Yes.
Okay. And so I know there was some evidence and testimony about the condition of the lock on the screen. Evidently, it was still in the lock position, even though it was opened.
Correct.
Okay. And was there testimony that it was not very secure? Because I don't know what kind she had, but I know most screen doors, for patio doors aren't that, hard to open up even when they're locked. Was there any testimony about that?
There was testimony that before the incident happened, that the lock was engaged, that she had locked the door, and that it would not have been difficult to manipulate or circumvent the lock, but that the door was open. And there was no testimony to dispute the fact that the door was open when, I don't think that there was any testimony to dispute the fact that the door had been opened.
Okay, when you say the door is opened, you mean it was not in the
it was not intact.
Yes, what I was going to say, intact. It had actually been slid open.
Slid and open, okay. Correct.
All right.
Yes.
And then I just wanted to differentiate that, make sure in my mind, if we're talking about open, meaning the door was opened, meaning moved, or whether the lock was unlocked.
It had been moved.
Okay. And the lock was still in the lock position.
I believe so. But the victim further went on to testify that she observed Banfield standing with both hands cupped over his eyes and peering through the window for several seconds before he reached down in an attempt to grab the inner handle of the back sliding door. The state would submit that he did use force to manipulate the lock and opened the outer screen door, which raised the inference that Banfield intended to commit a crime once inside the residence. And Banfield did not challenge this use of force in his sufficiency argument, but merely asserted that while his conduct, and including peering through the victim's back door and merely not having any criminal tools may have appeared suspicious, it did not illustrate an intent to commit a crime. However, under a sufficiency review, this court is required to view the evidence in a light most favorable to the state, and the state submits that, as in Daly, its evidence, if believed, was sufficient to give rise to an inference that Banfield either attempted to enter the victim's home, intending to commit an offense inside, but left when he was unable to open the glass door and or heard the victim yell out and then retreated down the steps. As to the manifest weight argument, the state submits that after this court reviews the entire record, weighs the evidence, and makes all reasonable inferences, it should conclude that Banfield's conviction does not require reversal. In arguing his conviction is against the weight of the evidence, Banfield essentially asserts that there were other plausible explanations for his conduct, which negate the inference that he intended to commit a criminal offense once inside the victim's home. However, courts have held that even when an accused offers an innocent explanation for his conduct, a fact finder is not required to accept a competing inference of innocence if it may infer guilt from that same circumstances. Competing with what Banfield calls innocent explanations for his conduct was the state's evidence, particularly evidence of the use of force previously discussed. Here, the trial court was simply not required to accept Banfield's explanations for his conduct. Under a manifest weight review, Banfield's explanations do not explain why he did not use the victim's front door like a typical social visitor, but rather forced open the victim's locked screen door and reached for the inner door handle if all he was doing was looking to see if someone was home. Nor do they explain why he became startled and retreated down the steps once he realized the victim was in fact inside the residence if he had an innocent explanation for being at her back door. As to Banfield's arguments regarding the judge's comments on his right to remain silent, that argument the state submits fails. In response to Banfield's argument, the state cited the Ohio Supreme Court's case in State v. Leach. And in Leach, the High Court explained that the Fifth Amendment right against self-incrimination prohibits the introduction of pre-arrest silence where the silence is used by the state as evidence of guilt. Leach differs from the present case in several ways. In Leach, the prosecution used evidence of the defendant's pre-arrest silence in its opening statements, case in chief, and closing statements as substantive evidence of the defendant's guilt. Here, Banfield does not argue, and it cannot be asserted that the state in any way used silence against him as evidence of guilt. Rather, Banfield argues that the trial court did so in commenting in the course of its deliberations from the bench after being offered several innocent explanations for his conduct. Banfield identified an isolated statement from the trial court as having violated his Fifth Amendment right to remain silent. The state views the question as whether Banfield ever invoked a right to remain silent for purposes of the Fifth Amendment protections, however. The state submits that Banfield never invoked his right to remain silent. Ultimately, Banfield, in failing to open the door for law enforcement, never invoked his silence in the presence of law enforcement officers, so as to implicate the protections of the Fifth Amendment right to remain silent.
Was there evidence presented that he was present at the neighbor's house?
There was
When the
evidence
police
that
knocked on the door. I'm sorry.
Deputy Foley knocked on the door, correct. There was evidence presented by the state that Deputy Foley knocked on the door.
Right, but was there evidence that, how do we know he was present? How do we know he didn't run down to the gas station? Or how do we know that he didn't run across the street and check somebody else's house out? I mean, you know, anything could happen. Well, how do we not know?
I don't
So
believe
how-
there. Go ahead.
Okay, go ahead. No, go ahead.
I don't believe there was evidence to that effect presented by the state.
So how did the trial court use that against him, saying he could have opened the door and said,
The
you know,
court
this
drew
is just
that
all innocent?
inference. The court drew that inference.
An inference that he was home
Correct.
and just wouldn't open a door.
Correct. The state would submit that the trial's comment on Banfield's silence, and the state would also note that there was no objection to this this comment during the rendering of the verdict, and Banfield has conceded that this review should be under a plain error analysis. He has not developed that plain error analysis for the court, and he has cited to plain error in his brief, but he has not developed that argument. And we would submit that any comment on Banfield's supposed silence was not error, plain or otherwise. And his last contention that the trial court relied on information from the state's discovery file as an extrajudicial source to arrive at his sentence is also without merit. Here, the state complied with discovery in this matter. On October 21st, 2019, it filed a discovery response containing a detailed list of Banfield's prior criminal record, which included 2 felony burglary convictions from Florida and an attempted burglary conviction out of Medina County, for which he served 2 years in prison. Banfield, in fact, waived a PSI, so the court at sentencing noted that it had reviewed the state's discovery to make sure it was at least broadly aware of Banfield's prior record because it did not have a PSI. Ultimately, but prior to sentencing Banfield, the trial court noted that after a review of the materials contained in the state's discovery, the matters presented at sentencing and by the parties during the sentencing hearing, the trial court sentenced Banfield to 30 months. Banfield now identifies that discovery as an extrajudicial source. However, he does not identify how this judicial source resulted in bias in any way because the discovery was part of the judicial proceedings. Judicial source doctrine requires that the source be from outside the judicial proceedings to give rise to the claim of bias. And rendering its sentence.
Counsel?
Yes.
Counsel, let me interrupt. So I just want to make sure I understand. So you're saying that the discovery file was actually part of the record before the trial court?
Discovery pleading.
Okay. It was part of the record before the trial court. So it will be in our appellate record.
A pleading should be.
And
Not a
that's all
file.
that's all the judge could have looked at then.
That is what I believe.
Okay.
So for those reasons, the state would submit that there was no error at sentencing, and in total and in conclusion, the state would ask that the trial court's decision and Banfield's convictions be affirmed.
Thank you, counsel. Counsel for the appellant, you have 5 minutes remaining.
Thank you, Your Honor. In regard to the third assignment of error, the state cited State versus Leach from the Ohio Supreme Court in 2004. And Leach does not contradict the prevailing constitutional law about how pre-arrest silence cannot be used as substantive evidence as guilt. So in fact, Leach, the primary case that Leach cites is from the Federal Sixth Circuit Court of Appeal, which is Combs versus Coyle from 2000. And in those cases follow the prior U.S. Supreme Court case precedent that pre-arrest silence cannot be used as substantive evidence as guilt. And the trial court admitted that in its deliberations and finding him guilty, that it had a difficult time believing that there was an innocent explanation for Banfield being at the back door, because he did not provide an explanation to police. And again, there was no requirement for Mr. Banfield to explain anything to anybody. He had an absolute right to keep silent. It's the state's burden to produce the evidence that he did not have an innocent explanation for being there. In fact, the law is supposed to presume that he has an innocent explanation, and it's the state that's required to produce substantive evidence that says no, he did not. And so, and that also kind of ties into the first assignment of error, where the elements of burglary and attempted burglary, like in this case, there's several elements that have to be met, and all of them have to be met. And just because they might have trespass and force and etc., if they fall short on any one particular element that's required in burglary, all the state has is a trespass, and that's all they have in this case. I get where the optics of Mr. Banfield trying to open the back door does not look good, but it's still the state's burden of proof to show that he had an intent to commit a crime, and they did not produce any substantive evidence, such as the criminal tools, or that he had any knowledge that the victim was going to be at the home, or or that any intent to commit physical violence, or any intent to grab any property and take it with him. There's all the state sufficiently proved in this case was trespass, and even though one can get very close to meeting each and every element, but if they fall just short, it's not a burglary and it's not an attempted burglary, and it still remains a trespass. Even if somebody just walks into a house without privilege or without authorization, it's only just a trespass, unless there even if there's force involved, it's still just a trespass unless there is proof of the intent to commit a crime, and that's where the state fell short in this case. And ultimately, the way that was made up was, oh well, Mr. Banfield didn't explain himself as to why he was there, which then effectively it violates his constitutional right to silence, and especially in the pre-arrest phase. So for those reasons, I would ask the court to reverse and remand.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to both sides, as well as posted on the Ohio Supreme Court website.